Good afternoon, folks. We are here for the guardianship probate docket, but since we're starting a little bit late, some of you may also be here for civil docket. So if you're on for our civil docket that starts at 2, you might, feel free to log off and log back in 30 to 45 minutes. We're going to take guardianship probate first. And we have quite a few matters on that docket. So just a heads up to those of you waiting for civil. Good afternoon. I'm Commissioner Jill Carmy. For any of you who don't know me, I guess I'll give the parties a heads up, especially on represented matters. I don't have in front of me very many original orders to sign. I see a lot of these are on for triannual review. Typically, I would receive orders that I'd be going over and signing. So if you're one of those cases where perhaps you need more time to prepare and present an order to the court, let me know and we can get you moved over to a different date.
Yeah, bring that, give me the name of that, your renter.
And their phone number.
Okay, I'm going to mute folks if we haven't called your case. Let me start with this. Are there any strikes or setovers on our guardianship probate docket?
Number 1 on the docket, Your Honor, Amanda Prujan for the Guardian.
Okay, go ahead.
This is on for a triennial review and we need to set this over. I've not been able to get a hold of Mr. Frederick. I think it's vacation time and we just keep missing one another. If we could set this over to maybe August 9th or 16th.
Okay. Understood. Let me just pull up that case here. This will be 044000465. And it looks like, do you have any issues with, it looks like the expiration for some of the letters of guardianship will expire before we meet again.
I don't expect it to be a problem. He's
Okay.
been in the same adult family home for years and
Okay.
that payee.
Okay, I could give you either of those dates, whatever your preference is.
Let's do the 16th just to be sure that we get all the stuff together and get notice out in time. And
Sounds good. We'll reset you to Wednesday, August 16th on the 145 docket.
okay, thank you.
Thank you. Do you have any other matters on this docket?
I do not.
Okay, have a good day.
Thank you.
Your Honor, this is Scott Blinks, number 15 on the docket.
Okay.
Guardianship of Diane Osborne also needs to be reset. The court visitor needs additional time for a medical evaluation. We're asking for August 23rd.
Okay, let me get to that case. This will be 234-0018808. This was originally, it looks like set on for approval of the petition. Is that correct?
Yes, Your Honor.
Okay. We will go ahead and will you send in a new notice of hearing to anyone who needs notice for this, or does the court?
I'm happy to do that, Your Honor.
Is that okay? Okay,
Yes.
perfect. Okay, Mr. Blinks, we'll have you go ahead and renote it then for, give me the date again.
August 23rd.
August 23rd at 1:45. Thank you so much.
Thank you.
And then I see I have you on a couple other matters, or at least one other matter. Do you expect that to go forward today?
I have 3 other matters.
Okay.
I expect 2 of them to go forward. I expect one to be continued. The one I expect to be continued is number 13 on the docket, guardianship of Deborah Carroll.
All right, let's call that matter number 13. This is 234-0015708. And Mr. Blinks, your client in that matter is who?
She is on the Zoom platform. It's Alina Guerrero.
Okay, let me just get into my digital file here.
Just to get up to speed, Attorney Michael Fry represents the initial petitioner. I represent the counter petitioner, and Tracy Grindstaff is the court visitor.
Good afternoon, Mr. Fry.
Good afternoon, Your Honor. In terms of my representation of the petitioner, there's been some different conflicting emails going back and forth as we tried to prepare for today. And I understood that due to the confusion regarding the court visitors report and my client's kind of late arriving position, the other parties would be requesting a 2-week set over. Currently, Deborah Carroll, the individual we're talking about, she is residing up with one of the other family members and is not with Lena Guerrero, who's Mr. Blink's client. And I think that we'd like to maintain the status quo and set over if that's what the consensus is here. The bottom line is Tad Cruz, my client, petitioned the court to become a conservator and guardian over his sister based on his promises to protect his sister. There's been a lot of, this is a very complicated case.
Mhm.
And he's now, I've advised both Mr. Blinks and as well as the court visitor that my client is now in the position of agreeing with the court visitor's report. He's just trying to maintain his right to continue to have regular in-person visits with his sister, Deborah Carroll. He wants to have notice and copies of everything that's going on here. And he's also asking, for reimbursement of his costs and attorney's fees, costs and everything else in bringing this matter before the court. Probably none of that is, Your Honor is able to address today. Although this is an important date because we were hoping to have the guardianship put in place today, and it sounds like it's either going to go to a contested hearing or maybe we can work out a stipulation. And I just don't know at this point.
Okay. So is the party's preference that we get you all on a trial assignment docket for a contested hearing, or do you want to set a 2-week review date and we'll reassess at that time?
Yeah, this is Scott Blinks. It's my suggestion that we set a new review date for August 2nd. And if it appears that it's not going to be resolved on August 2nd before that date, I will do a trial setting notice.
I think that seems to make a lot of sense. Mr. Fry, would you be in agreement with that procedural plan?
Oh, sure. I'm in agreement with Mr. Blinks. I think that's a good plan.
Okay. So let's set this matter over to the August 2nd 145 docket for review and potential approval of petition, I suppose, if there's an agreement. Otherwise, we'll, I guess, direct you all to the universal trial assignment. We'll get trial dates for you.
I just want to make sure the court's aware. I've not amended my petition on behalf of Tad Cruz, but I just stated my position. I've sent a letter out to the counter petitioners council as well as the court visitor, and so hopefully we can work it out between now and August 2nd. If not, we'll set it for a contested hearing.
Okay, thank you. I appreciate your input, both of you. And then let me call, I think, Mr. Brault, I see you online. This is 234-0007-608, estate of Diana Carr. Good afternoon.
Good afternoon, Your Honor.
On this, good. Do we have opposing parties on this matter? I did receive some responsive documents.
Your Honor, Josh Daly for John Carr.
Okay. So I'll let the parties give me some feedback, but Mr. Daly, on this docket, because I recuse typically on Mr. Brault's cases, I would like to move you guys over 1 week to Judge Basher's guardianship probate docket. I apologize for any inconvenience. I wasn't originally scheduled on this docket, so I couldn't give you more heads up than that. Are you both okay with being moved over 1 week to next Wednesday at 1:45?
I'm not available the next 2 Wednesdays, Your Honor.
Okay,
Your Honor,
go ahead.
and Mr. Daly can correct me if I'm wrong. I really asked for this to be set just so that Ms. McCoy presented documents that the court had requested her give me by last Friday, which she
Okay.
had.
Okay,
And that was the main reason for the review today. I know that we have a presentation that was set for Friday that has been kicked for another Friday. But Mr. Daly, unless there was something else, I don't know that we need this set over.
Yeah, I don't have any issues before the court, and yeah, I will not be appearing at the presentation for that order, but I don't see any issue with it, so I can sign that order and email it over to you.
I
okay.
appreciate it. Thank you.
So it sounds like we can strike today's matter then?
Yes, I just want to put it on the record that Ms. McCoy did comply with the court's order of last week.
Perfect. I appreciate that, and I certainly feel comfortable having the clerks note that without me needing to recuse, and we'll go ahead and note that in the clerk's minutes and strike this matter. And then you all do have a presentation scheduled. Do you have any other matters on this docket? I didn't think so.
I do not, Your Honor. Thank you very much.
Okay. All right. Mr. Daly, Mr. Brault, have a good afternoon.
Thank you, Your Honor.
Okay. Any other attorney matters that are ready to be called?
Yes, Your Honor, number 4, guardianship of Michael Blake. It's on for periodic reporting. This is Scott Blinks, and you should have a proposed order.
All right, let me get into my digital file and then check my documents. Give me just a minute. This will be 16-4000329. This is in the Blake matter. Don't think, and this is usually I have a lot more orders to sign on this docket, so that's what I didn't see that one yesterday. Yeah, I do see a proposed bench copy. Give me just a minute here. We could go through the proposed bench copy, Mr. Blink, and yeah, I think all the court has received is the proposed. Would you have recently filed an original for signature?
Yes, Your Honor. On July 3rd, I mailed a letter to the clerk of the court with 3 copies of the order, 1 original, 1 bench copy, and 1 to file, with instructions, requests that they file 1 copy and then forward the bench copy and the original order to your attention.
Yeah, and I absolutely believe you. I don't disbelieve you at all. Somewhere in that process, I have ended up with the bench copy, but not the original. So let's go through it. And then what I'll have you do, I can give you my judicial assistant's email address. If you're able to just shoot over a clean copy without the proposed and bench copy stamp on it, then I can sign that and file it.
Marvelous.
Okay, so I have reviewed this. Is there any additional input beyond what's in this review that you want the court to know?
No, Your Honor, this is on for routine reporting and nothing material has changed.
I reviewed it. My only question was with regard to the next review date. Is that something that you'll note on closer to the date, or did you want that set?
I'll note it as we approach the date, Your Honor.
Okay. Okay. Otherwise, I have reviewed the report, the fees, the everything else appears reasonable, and I will sign that again, since I just have the proposed copy. If you just could email over, I'm gonna put in the chat because other folks may need this. I'm just gonna put my judicial assistant's email address. I'm gonna double check that I'm giving you the right email address before I send it. WIRKKALAS, cowlitzwa.gov. All right, I'm gonna shoot this out. Everyone's gonna see this. So if anybody else needs my judicial assistant's email, there it is. Feel free to send Sylvia a copy of that and I will get it signed off docket.
Thank you.
Okay. And then did you have another matter to call as well?
I have one other matter, Your Honor. It's number 16 on the docket, guardianship of Robert D. Satcher. I represent the petitioner. Tracy Grindstaff is the court visitor. It's cause number 23-4-00212-08. It's before you on a petition to appoint a limited guardian and full conservator. The proposed guardian conservator is Sunset Guardians. Their representative, Sherry White, is also on the Zoom platform, and I believe that Mr. Satcher may be on the Zoom platform as well from his care facility. You should have a proposed order, and we hope that you don't have any questions, that you'll enter it.
And Your Honor, this is Jennifer Nugent, and I'm here on behalf of Sunset Guardians.
Okay. And have you had a chance to review the proposed order for Mr. Blinks?
I have, and there are no objections.
Okay. And then the court visitor, Ms. Grindstaff, I did review this file along with your involvement in this case. Any additional input you want to give the court?
No, there's no further information, Your Honor.
Okay. And have you had a chance to review the proposed order that Mr. Blinks has submitted to the court?
Yes, I have.
Okay. And any objections to that order to be noted?
No.
Okay. And then did we have another party? You said you thought perhaps Mr. Satcher himself was online.
I spoke to Donna Ford, the social services party at the care facility yesterday, forwarded Zoom information. They were going to try to appear unless something came up. I don't see them on the Zoom platform, but everything is in order to proceed.
Okay. Yes, and I did review this. Ms. Grindstaff, thank you for your involvement in this case. The court finds it very helpful. Thank you for presentation of the order. I will sign the order as presented. I would say the only issue is, again, for whatever reason, the original order has been lost in translation along its way to me. So if you're able, Mr. Blinks, to also email a clean copy to that same email address, I will make sure to get that signed and filed for you today.
Happy to do so. It'll happen in a few minutes.
Thank you so much. And is that the last case that you have on this docket?
Yes, Your Honor. Thank you for your
All
time.
right. Yes, thank you. Any other attorney matters?
I have number 8, Your Honor, Canon Jacobs.
Okay. So this will be 19-4-0000508. This is the guardianship of Canon Jacobs. And who do I have present on that matter?
Jennifer Nugent on behalf of Sunset Guardians. Your Honor, we're on for approval of the triennial report, and I do not anticipate anyone else will be present.
And I'll just check, is there anyone else logged into Zoom on the guardianship of Canon Jacobs? Okay. Is someone trying to speak, or are you on a different case? Okay. Give me just a minute. My digital file is being difficult, right? There we go. Okay, and let's see, I think they're along with it is the motion and affidavit declaration for attorney fees and costs. Is that correct?
Yes, Your Honor.
Okay. So You probably also submitted an original order, I am guessing.
I did.
You should have, should I? Okay. Yeah. This is what surprises me is I did not get very many original orders. And I don't think I have this one. I'm just looking through it again. I do see it online digitally. Different case. I do not have it in front of me.
Shall I email it to your judicial assistant?
You didn't have it right now. Mm-mm. So let me just look through my folder one more time. Maybe it got paper clipped to something else. Oh, that might be the solution here. Found it. It was
Yay.
it was paper clipped to 2 other orders. Mystery solved. Okay. So I do have this and I have reviewed the digital copy. So good to know we have the original here. I will go ahead and sign this. Oops. And then I think that is all on that matter. Was there anything else you needed on this matter, Ms. Nugent?
No, thank you, Your Honor.
Okay, I do have that signed and I'll hand that to the clerk.
Thank you.
Or I'll just put them there. I'm glad you told me to keep looking. And Ms. Nugent, do you have any other matters on this docket?
I do not, Your Honor. Thank you.
Okay, thank you. Have a good afternoon.
You as well.
Yes, Ms. Lyon, I see you there. Do you have a matter ready?
I do, Your Honor. This would
Okay.
be the matter of Barbara Turner, cause number 23-4-00071-08. And I believe also here present on behalf of APS, on behalf of the Department of Social and Health Services, is social worker Monica Hartel. The court visitor, Tracy Grindstaff, is also present, and respondent's attorney, Mr. Donald Aesop, is also present today, Your Honor.
Good afternoon, folks. Thank you all for being here. And I have received the packet from you, Ms. Lyon, with all of the documents in this case, including the notice of petition, the sealed declaration, et cetera. And I have the petition to appoint attorney for respondent. I have an amended petition for guardianship. So I'll let you go ahead and let the court know what you're asking for today.
Thank you, Your Honor. This hearing was originally scheduled as a petition on a hearing on the petition. Ms. Grindstaff has filed her court report with recommendations, as well as Dr. Maharg's recent evaluation of Ms. Turner. We found the parties discovered this morning, or were informed by Mr. Aesop, that Ms. Turner would like to contest with a bench trial. So
Okay.
I believe that we need to have this scheduled on the trial setting calendar in order to get a trial date. Your Honor, I do want to let the parties know that the state does remain concerned about Ms. Turner's welfare, as well as her estate at this point, with being in foreclosure. So the state would prefer to have this matter heard sooner than later, because it is possible that the state is going to need to consider filing emergency guardianship and/or conservatorship if this isn't resolved.
Yeah. And I'll let the parties weigh in, but I think that makes a lot of sense, given my review of this case. I think getting you all on the trial setting docket, I could get you on next week's Wednesday trial setting docket. And I can make a note regarding trying to get this heard sooner than later. Obviously, criminal cases may impact that. So let me hear from the parties involved in this. Does anyone object to moving forward in that capacity?
The respondent does not object, Your Honor. This is Don Esau for Barbara Turner, the respondent.
Okay,
So she is requesting a contested bench trial, Your Honor.
okay,
I have no objection, Your Honor.
okay.
I have no objection either.
Okay, so let's get you all, what I will do so that you kind of save a little time and don't have to separately file. I'm going to set you to next Wednesday, July 19. Is that still open? Is the trial assignment open? Okay. We'll set you to the universal trial assignment docket next Wednesday, July 19th at 1 o'clock.
At 1 o'clock?
1 o'clock, yes. And there will be, just like the Zoom link for this, when you log on Wednesday, you'll see the Zoom link for universal trial assignment. That should be with Judge Basher next week, I believe.
Okay.
Thank you, Your Honor.
Yes, thank you. Anything
Thank
else
you.
we need to
Thank
do
you.
today on that matter? Okay. All right. And then I saw Ms. Payne, you log on, and I think you have the matter of Roger Powell. Is that ready?
Yes, that is correct. And
Okay.
Attorney Mancuso, who is the petitioner's attorney, and Tracy Grindstaff, the court visitor, are also on Zoom with us.
Okay, so I have 234-001-4808. I do see both of you present. How are you? And I will tell you, I have received the bench copy of the petition and declaration in support of payment for respondents' attorney fees and costs, which looks like an amended copy. Are we going to be addressing that today as well?
Yes, Your Honor.
Okay. Let me just get into the digital file here. There we go. Okay, how are the parties asking to proceed on this?
So Your Honor, this started as emergency petition under that case number. Then I filed another standard petition, and those cases have been consolidated. And so I think we're actually at the point where we have an agreed order of appointment for limited guardianship and full conservatorship. The respondent probably is not on there. I don't see him. I did check the jail roster and bookings today. He's not there. He was personally served on June 27th. So I think we're all ready to proceed. The proposed guardians, it's going to be co-guardians, they're both on Zoom and are present. The issue that is left on the proposed order, which I just emailed to your JA, so you can see it before you right now, is the issue of fees for both the court visitor and the respondent's attorney. From the petitioner's point of view, we just feel like that would be a hardship to grant their full amount that they're requesting, as he only has about $13,000 left in his savings and checking account, and his Social Security, which is his only income, is $1,546. So if the full amount that both of them are asking for, it's going to take away even more than half of what he has left. And the petitioners really want to use that for other things that the respondent may need.
And so, yeah, I don't have the proposed agreed order but for attorney fees and costs. I don't have that in front of me.
No, all the parties were digitally working on it. And so I just emailed it to you.
Okay.
And it has, let's see, for the court visitor, she was requesting $5,430.
$5,430.
Correct. And respondent's attorney would be $3,360.25. Or at county pay, it would be $1,940. And I think she stated on there, I think it was 13 hours. I can't remember for the visitor how much were total, but hers were on both petitions that she was on.
And Your
And
Honor,
the
I'm
issue
happy to
really
address
is-
the fees as well.
Yes, absolutely. So go ahead, Ms. Mancuso, was there anything else you wanted the court to know on that?
And it's just regarding how much is left over. So even though it's more than 3,000, it really doesn't leave a lot left for the things that the parents are trying to later on burst for a few expenses that they paid out of pocket, and just to have things left for his medical care. And so he has some sort of savings left.
Mhm. Okay, Ms. Kane, your position, and I do have a hard copy of your declaration with fees and costs, so go ahead.
Your Honor, my client does not agree with the guardianship, but he has given me no direction to contest this. I was able to speak with him one time and he declined any further communication. And so according to my statutory duties, I have advocated for the least restrictive in scope, duration, and the proposed order is that least restrictive. So I believe I have met my duties on that. Regarding the fees, under RCW 11-130-280 and .285, the court has authority to order payment of the court visitor fees and the respondent's attorney fees at county expense if the court finds that even though the person has over $3,000, it would create a substantial hardship for the respondent. And I think this situation is distinctly different than there's so many cases that come where we might have $10,000 to $20,000. But very often these folks are on a Medicaid spend down. They are either in or going into an adult family home. And once their funds are spent down to $2,000, even if all of that money is used up on paying for fees, they then qualify for Medicaid, and Medicaid makes sure that all of their housing and care costs are paid for. But in this situation, Mr. Powell is living his own apartment. I understand that he and the proposed guardians anticipate he will continue living in his own apartment. Therefore, we don't have a Medicaid spend down. And if our fees are paid privately, so I added up my fees and the court visitors fees, the total would be $8,790. With his current balance of $13,000, that would leave $4,410 of funds. And I believe that would be a hardship for trying to maintain him in his apartment. So I think it would be appropriate that the county would bear the cost of my fees and the court visitors fees.
Okay, and I'm just and thank you. And our court visitor on this case, are you with us?
Yes, Tracy
Okay.
Grindstaff. Yes.
Oh, thank you, Ms. Grindstaff. Originally, we had narrowed this Zoom hearing down to one page, but more people have logged in, so there's two again. So do you have any input you want to give on either the petition that's been emailed over that I haven't seen yet, but it sounds like it's agreed more or less, given the caveats Ms. Payne just explained as well. Do you have any input on that as well as the fees and costs discussion?
I agree with the order that's going to be presented. We have come to an agreement on that, and I think the terms are the least restrictive for the respondent and the most helpful moving forward. As far as the fees, this was an emergency case and a standard case. I have worked over 36 hours on this case, and it's been very involved from the beginning. A lot of time and a lot of energy and a lot of hours. Having said that, you know, I understand the hardship that goes into, but I'm also just trying to be paid for my services and time.
Mm-hmm. So I'm looking at the original order appointing court visitor, and it looks like at that time it was contemplated it would be at public expense. I don't know if that was changed. And again, I'm kind of coming into this at the tail end of this case. I'm just looking to see if there was an order that changed that in any way. Okay. So yeah, I see, I think I'm somewhat bound by the original order that did appoint this case at county expense. And then I see for the court visitor, and then the May 31, 2023 order that Commissioner Nelson signed appointing Ms. Payne contemplated a private pay hourly rate, but then stated that Ms. Payne is willing to accept payment at county expense at $150 per hour in the event the court orders payment of respondent's attorney fees at county pay. It sounds to me like there would be a hardship if I did not direct county pay for both the court visitor and the respondent's attorney. So I do think that will be my order in this case. I don't know what that does to the proposed order you have sent to me. If you want to revise that based on county pay findings and then resubmit.
Your Honor, I left a blank and a checkbox for either way.
Okay.
So that you were able to put in the total amount and where it comes from, either the respondent's assets or county.
Okay. So, and then the parties with the county pay, then what will be the totals for Ms. Payne? I think you gave me that number.
I did. It would be 1,950.
950. Okay, I wrote 940. So thank you. So that'll be Ms. Payne. And then for Ms. Grindstaff, what will be the total amount to include in that order for you?
At county pay would be $2,443.50.
Okay.
I would like to note that there still hasn't been a initial accounting from the emergency guardianship. So there is no tracking of how much money was there when it started as opposed to how much money is there now.
Okay. What if we do this? Especially since I don't have it in front of me, and now Ms. Grindstaff with you talking about an accounting, what I will do is I'm going to use the numbers in the order that was proposed. I want to set a review date 30 days out to see if an accounting has been provided. And what I'm going to do on the order that's with my judicial assistant right now, below the fees and costs, I'm going to put reserve on additional reimbursement at next review. And that just gives me some leeway if perhaps there is a difference in what we think the accounting balance is or was, and that there is additional room, because I see, I mean, essentially, here's my concern. I feel like I'm essentially cutting the professionals' fees in half, given the significant amount of work that's been done in this case. So I want to review this in 30 days and reserve on whether I think additional reimbursement should come on this case. Okay.
That's fine, Your Honor, because I want everybody to get paid too, as well as protecting Mr. Powell on this. I know initially on the very first interim report on the emergency petition, and it was estimated he had about $18,000 bank account. And I think that's also because my clients have also paid out some things out of their own pocket, which I needed to submit anyway. I've been working on that accounting and kind of wanted to make sure this got handled first, because this case has continued so many different times that need really to get resolved today. So thank you.
Absolutely. Okay. So would it work for the parties to come back on this docket August 9th for that review? And it would really just be specific to whether I feel there's, I guess, whether I think that there should be additional reimbursement from the account for the professional fees in this case, based on that accounting that will be filed?
I'm fine with that date, Your Honor.
That date works for me as well.
Okay.
Your Honor, I'm sorry, I will be out of town and unavailable on that date. I'm going to leave it to the court's discretion.
Okay.
On that and go ahead and do that on the 9th. I really appreciate your consideration of the fact that Ms. Grindstaff and I have done the work, but we're also trying to be considerate of Mr. Powell. So thank you for your consideration.
Yes, I certainly understand that. So, and thank you for essentially, I'll note you waive your appearance for that August 9th hearing, and the court will keep you informed as to our ultimate decision on that. Since it is an agreed order, even though I don't have it in front of me, absent me getting it and having a concern, if I have a concern, I'll have the court reach out to all the parties. But otherwise I will sign it, and then we'll be back on August 9th for that short review.
Thank
Oh,
you.
go ahead.
Are we sending both of the case numbers over to that date because the cases are not consolidated? There's two different ones.
Oh, I do see that.
Sending just
So,
the or
It should be consolidated under the 148 case number, Your Honor.
Okay, so let's do this. Let's do a form. Yeah, our docket still has them separate for some reason. So thank you to the court for catching that. Let's put in my notes that if it has not already occurred for procedural and judicial purposes, these numbers are consolidated into the, you said 14808 matter.
well,
That's correct, Your Honor.
Yeah,
we would need an order consolidating, and we don't have that.
we don't have an order consolidating. Okay.
It was in an order. I can do a separate order just on that, just so it's very clear for the clerks.
That would be great. I think that is what we're missing. And then that way we're going to see it all together on our docket. So yes, Ms. Mancuso, if you submit that order, you can do that ex parte and I will sign it. And then we will, for now, until we have that order, then for the court's information, 17508 will also go to August 9th. So thank you. Okay. Absent anything else on that matter, you folks are free to log out.
Thank you, Your Honor.
Thank you.
Again, thank you, Your Honor.
Yes, thank you. And then I'll just tell the folks that are here on our civil docket, we just have a couple more guardianship probate matters. We'll try and get through those as quickly as possible. I'm going to go to number 2 on that docket, which is guardianship of Megan Davenport. Do we have anyone present on that matter?
Yes, I'm here. Sorry about that.
Okay, no problem. Let me just open up the digital file here.
Okay.
This is 0940000385. We're here for my notes for the triannual review.
Right.
I don't have any documents in front of me. I'll double check my stack here, but what can you tell me
You probably won't find any dockets because he was just going to review it, look at it, what we had there, but we're asking to have it closed actually.
You're seeking to close the guardianship?
Yes, we are.
Okay, I'm looking at Commissioner Nelson's notes from June 21. Did he appoint Sherry Farr at that point as a court visitor?
He said he did. I haven't seen her though.
Yeah. Well, that was, and I don't think, do we have Miss Farr with us? No, he didn't do an order. Okay. So his ruling was to end the guardianship because, excuse me, he had originally denied the motion to close the guardianship and instead appointed Sherry Farr as a court visitor to advise the court on whether it was appropriate to end the guardianship. So what I can do for you today is get that order drafted and get Ms. Farr formally appointed as a court visitor. And then let's set this out. It doesn't look like we have any emergency issues to deal with.
No, there isn't.
So let's, to give her some time, let's set this out about what would be standard beyond 30 days, like 45? Okay. So let's go to August 30th.
Okay.
At 1:45.
Now, there was a court hearing set for August 19th, or not August, sorry, July 19th. That needs to be taken off the docket then, because that was when they were supposed to hear it.
Oh, I do see
Which
that.
is, yes.
I do see that they have that. Yeah, and if we don't have the order appointing Ms. Farr, so let's go ahead and strike July 19.
Thank
And
you.
instead, we'll renote this to the August 30th docket.
Okay.
Okay.
Sounds good.
All right. Thank you for being present and being patient.
You're welcome. Not a problem.
All right.
I know how this can go.
Yes. All right, I have guardianship of Haley Gredig. This is number 3 on our docket. This is 12-4-00023-7. Do I have parties present on that matter? Is it Kathleen Gredig? Are you present? Do I have David Gredig, either of the co-guardians? Okay. I did see that they submitted an order approving a proposed budget, disbursements, periodic personal care plan, and periodic report and accounting. I'm not finding that it's complete. So I do want them to appear. We'll go ahead and note their non-appearance today, and I will have court administration send them a letter that they're gonna need to appear. Would we typically set that date or have them ask them to set that date?
Do you want me to send them a letter instead and I can set a date from that?
Let's do that if you don't mind. Okay. So we'll have the court renote this after a letter goes out to the parties asking for their appearance. We'll just ask them to appear for an annual review or a court review of their annual review order. Okay. Okay. And then I have a guardianship of Wade Christopher Pointer. This is 18-4-00-14008. Do I have any parties present on that matter?
Not wrong.
Okay, it looks like we are on for annual review. And again, I'll just ask, are there any folks here on the guardianship of Wade Christopher Pointer? Okay, I'm not seeing any documents filed in this matter since 2022. Typically, I think the court sends out a typical letter stating they've missed their review. Okay. Okay, we'll go ahead and the court will notify them of today's hearing and still having an outstanding annual review that will need to be presented to the court. Then I have number 6, 18-4-00-14108. Oh, is this a joint matter? Garrett, this is the guardianship of Garrett Pointer. I'm guessing no one is online for that case. same issue. We'll ask for the court to send a letter notifying them of the delinquent annual review. And then I think lastly on our guardianship docket, I have guardianship of Axel Peso. Is there a Jodine Dixon present on that matter? Okay. In this case, they did on June 29th submit an order approving report. And it looks like that was signed off docket on June 29th by Judge Hahn. So because that was reviewed and approved, and it does indicate the next review dates and reporting period, we'll go ahead and strike this matter. Okay. Is there anyone else on Zoom who is waiting for a case to be called on our guardianship probate docket?
Yes, Your Honor. David Rorden, I think it was item number 7, Ella Mayhew.
Yes, thank you. I just skipped right over you. Okay, so that's 18-4-00-25408. And I do have on that case what I have as a original copy is an order approving estate accounting and approving sale of the duplex.
Correct.
Is that correct?
Yes.
So go ahead with your request to the court while I pull up your digital file here.
Well, this is a request for approval of the accounting. I provided documentation for, provided it to Mr. Fry, who is representing the co-owner of the property. And he signed off on it. So we're just asking for approval of the accounting and approval of moving forward with the sale of the duplex. That was, the authority was not granted at the time the guardianship was transferred to probate, because the accounting on the duplex expenses lagged the accounting on the elements of the guardianship.
Okay, and I do see all of those sealed financial records were filed and received by this court, including the estate accounting on July 3rd. I do have your original order as well as the fax transmission copy that has both your signature and Mr. Fry's signature. Mr. Fry, any input from you?
This is an agreed order, Your Honor. I represent an agent for the co-owner of the subject property, and we've signed off on the order and asked that you sign it off as well, and we enter it in court.
Okay. So thank you. I have reviewed this file. I do have the original order. I have signed it, and that will be filed today.
Thank you.
Is there
Thank
anything
you.
else the parties need?
Nope.
No, Your
Okay.
Honor.
All right. Thank you both. Okay, and for fear of another oversight, is there anyone else that I have missed on our guardianship probate docket? Okay. I know you folks have been waiting patiently for civil docket to begin. Give us just a couple minutes to switch over. We're going to go off the record for a minute. We'll be back on the record in about 5 minutes. Thanks, folks. You can just stay where you are. You don't need to check any new Zoom link.
Hey, Terry. We're at a break right now, and it says Jill Carmy. Look up.
Dad, you need
Hello?
to mute yourself.
What? I need to mute myself? Okay.
Yes, mute yourself.
Okay. All right, good afternoon. I am ready to start our civil docket that should have begun at 2. Apologies for the prior 2 dockets going longer, and we are now starting at 3 o'clock. So let me just ask if there's any matters where attorneys need, you have other court appearances or other obligations given this late start, need to have their matters heard first. Wow, I thought maybe everyone would jump at that opportunity. Okay, then let me start with this. Are there, oh, go ahead, Mr. Jervakainen.
No, I just have a few relatively quick matters.
Okay.
As it pertains to restoration or registration lifting.
I did see those, and I think Mr. Morgan, you're on some of those. Are you with us?
I believe Mr. Morgan's present for number 12, Joel Hembry.
Okay.
Yeah, I'm also in a DOL hearing right now. Could we return to this matter?
Oh, yeah, we'll return to your matter. That's
Thank
fine.
you.
All right, let's see. The other matters, Mr. Jervakainen, are you on number 13, Scott Schroeder?
I am appearing on that one, Your Honor, which is cause number 23-2-620-08. My request actually pertaining to this one is a brief set over. This is a registration lifting request by Mr. Schroeder. I believe I saw Mr. Schroeder. Yeah, there he is. This was an instance involving Class B and Class C offenses, which do in the future permit him the opportunity to relieve his registration. Part of his sentence, though, from what I recall in the documentation, is he was granted a SOSA, which is more of a community-based supervision for a period of a number of years, which I don't believe was terminated until 2015, 2016. Would take it within that less than that 10-year window where somebody has the opportunity to request that their registration be lifted. The statute itself pertains to being in the community for at least 10 years with no disqualifying offenses. I guess I have a question in my head right now and would request further time to do a little research on whether, while somebody's under the supervision of DOC, which is effectively partial confinement, whether that counts towards time in the community towards that 10-year window. If it does count towards community time, then he falls within the statute of being able to request the court to relieve registration. If it is considered some form of confinement, then he would not be within that 10-year window. So I'm asking for more time to look into that issue.
Okay. And I do think that would be helpful for the court. I just know I haven't actually had that specific issue come in front of this court. So any additional briefing from the state, albeit as short as you want to make it, would be helpful. Mr. Schroeder, I'm going to grant the state just an additional time to file some documentation with the court so that we can make the right decision in this case. Are you opposed to a short set over of this matter?
No, Your Honor.
Okay. How much time are you asking for, Mr. Jervakainen?
Your Honor, I have a decent amount of out of office obligations next week. So I would make the request of 3 weeks, which will give me adequate time to get a response in early the following week.
Okay. And Mr. Schroeder, would you be available? That would put us to August 2nd at 2 o'clock. Would that work for you?
Yes, Your Honor.
Okay, great. So we'll set this matter over to August 2nd at 2 p.m. All right. Mr. Schroeder, you're free to log off. Thank you for being patient.
Thank you.
And
Court, please, number 3.
okay, and just 1 minute. I'm going to see if we have, do we have Vincent Esposito with us on number 15, Daryl Greger?
And Your Honor, I believe the state's filed a response on that one, but I have not had any contact with counsel.
Okay. Let me just pull that up quickly. It looks like the state is not opposing the restoration of firearm rights.
Your Honor, he appears to be eligible. Mr. Greger had a 2003 felony, Class C felony conviction. Trying to read this. Looks like a 2003, 2008. It looks like vacated in 22. Regardless, the requisite number of years have passed with no criminal convictions, as well as the healthcare authority report coming back clean. So he appears eligible.
Okay. Would you, he has presented his proposed order restoring right to possess firearms. Although he is not here today, which would be my preference, do you have an objection to me signing this order in his absence, or would you prefer this be reset and request his appearance?
I have no objection to Your Honor entering the order if you're finding that restoration is appropriate.
Okay. I will make that finding, and I have reviewed the order. We will get, I don't know why attorney is not present. He might still be logging on, but we'll go ahead and sign this order and get him a copy. Okay. And then I'll jump back to these cases. Oh, Mr. Morgan, are you ready?
I am, yes, Your Honor.
Okay, let's go ahead and finish up the restoration cases then. The next one I see is number 12, Joel Lester Hembry, 232-0059-408.
Yes, Your Honor. I believe the state agrees that he does meet the criteria for restoration of rights. I think they have signed off on said order.
And Your Honor, the state did file a response on the 6th indicating the healthcare authority report came back clear and that he does appear eligible for restoration. So I believe Mr. Morgan's support staff have acquired my signature, but if not, we can sign off on it and they can present it ex parte.
Okay.
Or if Your Honor has a copy of a proposed order from Mr. Morgan, I have no objection to entering it.
Okay, and Mr. Morgan, I don't have an original order to sign on this matter. I'm certainly happy to have you email it to my judicial assistant. I have her email. It's the last thing there in the chat. And it's probably the easiest way to get me an ex parte document without it getting lost in the shuffle.
Yeah, we will look for that. We sent that over a couple days ago. And unfortunately, the assistant that did so was out with COVID. So I will try and locate where that is and get it to your honor.
Okay, and I will sign that upon review and having reviewed the initial petition in the file and the response. And then I have Scott Wallace, 232-0062-62608.
And Judge, this is, I think, similarly situated where the state previously indicated they had no objection, that they did appear to meet the criteria for restoration. And my guess is you do not have an order because we sent them over together.
Okay.
And yes, Your Honor, the state did file a response indicating healthcare authority coming back clear, as well as I don't believe the individual had any disqualifying criminal convictions since 1996, which those are currently under seal. So he's had no history since then.
Okay. And I do see that in the file as well. And again, yes, if you just want to, Mr. Morgan, email over that order, I will get it signed for the parties.
Thank you. I'll do so and I will log off.
Okay. And then Mr. Jervakainen, are you here on any other? Oh, there is another one. It looks like
9.
Christopher Munson, number 9. Is Mr. Munson with us? This is 232-00-26208. Let me get there in our digital file. This one, it says we do have an order on. I do have the petition. And then Mr. Jervakainen, the response, I'll let you take it over, but it looks like there is an objection to this.
And Your Honor, I didn't realize the history of this, but it looks like there was a previous petition filed. I'm not sure what happened with it, but I did review this earlier last week. And in my review, I filed a response believing him to be ineligible at this time. Reason being is there's never been an involuntary commitment, so the healthcare authority report came back clear. But he does have, from what I gather in his history, there were a number of perhaps drug possession cases that have recently been vacated in the last couple of years. But nonetheless, he has a unlawful possession of firearms second-degree conviction in Grant County under cause number 08-1-9-1. He had an earlier 98 theft of a firearm conspiracy conviction. I believe that was a juvenile case in 99. But nonetheless, looking at his history since 2008, requiring for a felony conviction 5 years of no criminal convictions. His most recent conviction had a disposition date of February 12th of 2019 for resisting arrest, which I believe was also in Grant County. And between 2008 and 2019, he's never had a 5-year window without any criminal convictions. Looking at his gross misdemeanor history, he had 2 gross misdemeanors in 99, 1 in 2000, 1 in 2002, 2 in 2008, 1 in 2009, 5 in 2011, 1 in 12, 2 in 13, 1 in 14, 3 in 16, 1 in 17, and then the most recent 2019 resisting in Grant County. So according to my calculations, I don't see that he's eligible and having 5 years of no criminal convictions since his felony conviction in 2008.
Mm-hmm. Yeah, and I do see that prior petition, and it seems like perhaps that was granted, but then a new petition filed. I think all I can do at this point is based on the information provided by the PA's office and my review of the file. I will deny the amended order restoring petitioner's firearms right. I'll just also note in the clerk's minutes that he's non-appearing. So any questions about any of the underlying facts, I'm not able to ask. So I will deny this.
And I believe that concludes the matters I'm here for, Your Honor.
Okay, thank you so much. We'll see you back on the continued matter in 3 weeks, and have a good afternoon.
Thank you, you too.
Okay, someone asked for us to call number 3.
Yes, Your Honor. Number 3 is unopposed. Michael Long for the plaintiff. It's plaintiff's motion to amend pursuant to CR 15, amend the complaint. Representative to the court, I spoke to Mr. Vibert today, who said he was not going to appear and that he was not going to interpose any objections to the order authorizing the amendment.
Okay, let
And I
me,
believe the court has the original order there.
I do. This is one of the original orders I have for this docket. So thank you. This is 20200366908. I have the original order granting plaintiff leave to amend complaint. My understanding, I did review this file and I wasn't sure if we would be proceeding on oral argument on this. So I just did note that I had not yet received any written objection to it. I will take counsel's statement that this is an agreed order, and I will sign this order dated today, July 12th. And we will file that with the clerk.
Thank you, Your Honor.
Anything else? Do you have any other matters on this docket?
No, I do not. Appreciate
Okay.
it. Thank you.
Have a
Thank
good
you.
afternoon. Okay, any other attorney matters? I know we have quite a few matters that appear to be a little bit shorter in nature. Let's call some of those. I'm just going to hold off on the summary judgment case on the Silver Light construction. I think that might be one of our longer matters today.
Your Honor, number 1 and then number 2, those should be short.
Okay, let's go ahead and call number 1. This is 14-200-9055. Is Ms. Tideman with us? Good afternoon, Ms. Tideman.
Good afternoon.
And we have Mr. Ammons present.
Correct.
Good afternoon. How are we proceeding on this? My notes state we're resetting trial dates, but my notes can be wrong, so I'll let the parties fill me in.
Well, I filed a motion to reset the trial date because my expert witness, he's a professional surveyor, is not available. I initially thought, well, maybe I can just take his deposition, but reviewing the rule again, for whatever reason, the rule only allows to perpetuate a deposition for an expert for medical providers, and it leaves out the other experts. There are some reasons you can get in their testimony if they happen to be like deceased or live a long ways out of state, that sort of thing, but none of those apply to our expert. And so had I known about his unavailability, I would not have selected this date, but I don't see any real prejudice except some delay. I wouldn't ask for a very long extension of the trial date. I want to get this case tried too. But the prejudice to the defendant could be fairly extreme because this is a case that involves boundary line dispute and also an easement and the extent of that. My only option, if we can't reset it is to try to find a different expert that would be available, somebody that's not familiar, which would add to the expense. So I'm requesting the court allow us to reset it. And I did not receive any response to this. However, I did talk with Ms. Tideman this morning, and she did say that her client does not want to change the date.
Okay. Ms. Tideman, your client's position.
Yeah, we didn't file anything. My client, this has been a matter that's just been pending for a really long time. So he is anxious to get it completed. I did talk to Mr. Ammons today, and obviously if he were to have to select another expert, that might create difficulties with the current trial date anyway, is the reality. So I'm hesitant to make a real strong push here and then come back and say, never mind, now we need to move it because of a new expert. So we'll defer to the court, but my client does want to put on the record that, he's anxious to get this tried. It has been pending a long time, and he would prefer that the trial date stay in place.
Yeah. Understand both parties' position. I guess one of two things. I do think that it would be within my authority to issue an order allowing the perpetuation deposition of this expert in a civil case, on a finding of good cause, that otherwise this case will have to be rescheduled entirely. So I would propose that as an alternative to the parties if they prefer, but I also, was this scheduled on a civil priority week?
I don't believe so, Your Honor.
Okay. Yeah, so the reality is we're probably in a kind of a iffy place regardless if it's going to get out.
Yeah.
What I could do is, I hadn't talked to my client about this idea of the court ordering, allowing a perpetuation deposition. I would like to at least talk to him about that prior to, essentially agreeing to that. So I think we could do one of two things, depending on where the court's leaning. I could certainly talk to my client about that, and we could, come back on this matter with that information, or if the court is inclined to reset it, then we could put it on trial setting for next week, because I would need to get my dates together.
Yeah. And since this is your motion, is your preference? I'm not going to force a perpetuation deposition on you that you would rather take live. So
well, given that we're dealing with survey maps and things like that can stretch out to the size of this table as exhibits, perpetuation would be one way to do it, but it's really not the ideal way to try this sort of a case. So I'd prefer resetting it, and I will tell you, I want to get this case done. And I'm not asking for a long extension. We want to get it done.
Yeah. And so I think that makes sense. What I'll do is set you all to next week's universal trial assignment if you're both available.
I'm available.
But let me just really before I make statements here.
And then part of my reasoning for agreeing to strike this and have it reset is this morning on universal trial assignment. How long was this trial set for? How many days?
I believe 2 days.
Okay.
I could be wrong, but that's my recollection, Your Honor.
So yeah, we were still setting trials for the week of September 5th. So I bet as long as you're agreeing to trail criminal, which the only other option, I think the civil priorities, the next available dates, the first week of April, 2024.
Oh,
no. So you're probably going to take a trailing criminal anyway. And I bet they can still get you in September or October even. So.
Okay. That sounds good. I have a conflict next week, but I have someone who can cover, so we can go it on next week, and I will have someone to cover. If something happens with that, I'll contact Mr. Ammons.
Okay, great. So we'll strike the week of September 5th trial, if I got that right. Week of September 11th, excuse me. I see you have a proposed order. I don't know if I have an original.
I normally send one.
Yeah. Do you know hold on.
If you don't have the original, if you have one that at least has my photocopy signature, I don't have a problem with that.
Okay. Yeah, if you want to send, in the chat, I have the email for Sylvia, my judicial assistant's email address. If you just send that over via email without the, proposed language on it, or I can cross that out, I'll get that signed, but my oral ruling is we'll strike the week of September 11th trial and set you all to next week's trial assignment.
Thank you.
And then, okay, Ms. Tideman, you do have other matters, so I'll take number 2 with Mr. Ammons first, and then we'll come back to you.
And I believe Ms. Sturm is on the other side of this one.
There we go,
I am.
Ms.
Thank you.
Sturm.
And
Good
this,
afternoon.
this one is really the exact same issue, except we've already been this route once before, and I made the mistake of asking the court to make, can't we set it earlier than it was originally set? And so when I got the notice to my client to the expert on that one, he's an expert road builder. He said he wasn't available that week, so I had him do a declaration so we could pinpoint when he is available. And so I would request that the court also reset this one so he could be available. I did not receive any kind of an objection, and I don't know Ms. Sturm's position on this.
All right, Ms. Sturm, what's your client's position on this?
Essentially the same. My clients would object to any continuation of the trial. This has been a long time coming. We were originally set for trial in March. It got bumped. They want this trial to happen as soon as possible, but I will defer to the court.
Okay. And I think just given the witness unavailability, and I note this also appears to be a 2-day trial. Is that right?
I think it's set for a 2-day, yeah.
Okay. I'll go ahead and strike the trial date. I'll sign that order if you want to send that over as well. And we'll set you to next week's universal trial assignment to get a new date. And part of the reason I feel that this is an appropriate action is, again, given this morning's or this afternoon's settings, I think we could probably still get you pretty close to that week of September 25th right now.
Very well.
Anything else on that matter?
No, thank you.
That's it. Thank you. Your Honor.
Okay, thank you. Let's see, Ms. Long, I see you there for presentation of the CR 35 order. Are you ready to proceed on that?
I am, and this may be unopposed. That's the impression that I got.
Do we have counsel on behalf of Mr. Spain on this matter? There's a couple names I don't recognize, but none of them are Mr. Marinelli or the attorney who covered for him on this.
Yeah, there was a Mr. Ashraf Nomi, and then there was a woman that covered for him the last time. Mr. Martinelli's not part of the case anymore.
Oh, okay. Okay. So let me just pull up that digital file. This is 222-0076208. This is on for, oh, is someone trying to talk?
What was the number again?
This is 222-000. Mr. Larson, are you trying to talk to the court?
Okay, we'll fix you.
Okay, I think he's on the phone. So, okay. We will go back to what we were doing on presentation of this order, and I believe I do have a copy here. I don't have any objection to the attorney fees and costs that are requested that I did award at the time that I denied the CR 35 motion, and I don't see any objection to the order as proposed. And I'm just looking, I'm going to triple check. I don't see anything filed. So, Ms. Long, I'll just have you put your argument on the record for this and then I'll make my ruling.
Sure. This was a request for a CR 35 exam that the defense made twice in this case. It was twice denied. And so on that basis, I'm seeking an award of attorney's fees under the court rules having to do with motions to compel. The hourly rate that my staff and I are charging is, I think, more than reasonable. And I will also state for the record that I have corresponded with opposing counsel about this, and they have indicated that they had no objection to the amount of fees that I was claiming.
And then the total I have on the declaration is $2,396.50. Is that correct?
Yes.
Okay. I find that exceedingly reasonable given the history of that particular issue and the number of times the folks came to court on that particular issue. I would be inclined to require defendants pay that within 30 days unless you have another proposal.
That's fine.
Okay. All right, I have signed this order with the inclusion of attorney fees and 30-day timeline to pay, and we will file that with the court.
Great. That takes care of it. Thank you.
All right, thank you. Together. Okay, any other attorney matters that are ready to be presented?
Your Honor.
Yes, Mr. Claxton, go ahead.
Yeah, number 4 on the docket.
All right, let me get there. All right, 202-0056208. Patrick Connor.
Yeah, this is basically, we're just asking the court to go ahead and release the funds to our ILTA account to be distributed pursuant to the court order entered previously in the probate matter for Mr. Connor.
And do we expect anyone else appearing on that matter?
No, I don't. I've not received any responses, and I don't think anyone was objecting.
And I do have that order and I have reviewed it. I'm just going to pull up the digital file here. There we are. I see the certificate of mailing of the motion. I'm not hearing anyone on Zoom opposing or, excuse me, appearing, let alone opposing. I have reviewed the order. I will sign the order as presented.
Thank you.
Anything else on that matter?
No, Your Honor.
Okay, thank you. Have a good afternoon.
You too.
Okay, I'll go through. I think Ms. Tideman and Mr. Penta, we have number 8 on the docket. 232-0018408.
That's correct. That's my motion, Your Honor.
Okay, let me get the digital file pulled up. Okay. Okay, so I'm looking at the order that was signed, setting this to the civil docket to allow counsel to submit declaration of fees and costs. And then Mr. Nelson also indicated that defense would be allowed to challenge any fees requested. Then I have on July 10th, the certificate for attorney fees and costs and an affidavit of service. And that's the last thing I have. So are we here on Are we disputing the fees and costs being requested, or fill me in on what's being asked of the court today?
We're disputing the amount that was assessed by Mr. Nelson.
So, Your Honor, originally when when the motion to overturn the default order was granted, Commissioner Nelson ordered $1,000 in fees, which was my request. There was a reconsideration motion filed by the defendants, and per that reconsideration motion, Commissioner Nelson, did an order granting reconsideration as to the fees and to allow a fee affidavit to be, because there wasn't a fee affidavit at that original hearing. So I did submit the fee affidavit for the total costs that were incurred as a result of the default and challenging the request to overturn the default. My fees were greater than what was awarded. I had only requested the $1,000 at that hearing, but I did do the full fee affidavit so the court could see how much time and money was spent doing that.
And so then, Mr. Penta, what is your objection as far as fees and costs?
Well, thank you, Your Honor, but this is all about reasonableness. It's about reasonableness. I mean, unlike, for example, a case where a party was allowed to amend pleadings after the other side filed a motion for summary judgment, this claim for terms is over a routine filing of an answer. Specifically, my staff was 1 day late. We all know mistakes happen. Ironically, this is the second time in my career when I was overseas and staff missed a signed answer. The first time was 35 years ago. What happened then? The docket judge, without complaint or objection by plaintiff's counsel, continued that motion for default. Like here, there was no harm to the plaintiff. It was implicit, at least then, that no attorney in Cowlitz County would miss an answer filing deadline and allow a default. So fast forward 35 years today. I signed this answer before leaving for Europe. Staff was busy. The default was taken. I take responsibility for my staff. My staff errors are the attorney's errors. Here, the error was harmless. Staff left messages for plaintiff's counsel the next day to tender the answer. When she received no reply, she then contacted an associate to move to set aside the default. When I got word the next day in Europe, I emailed my apologies to plaintiff's counsel, requested we stipulate to setting aside the default. She actually sent me a kind reply, promising she would get back to me, but then nothing. She ignored the stipulation that my staff prepared and then demanded the terms when the motion to set aside was granted. The sanction amount was later questioned as unreasonable for these reasons. Number one, there's no prejudice to the plaintiff. The suit is new and will take its course. Other than the time to file the previously prepared default order, there's no billable time loss in taking the default. Terms of $200, $300, maybe even $400 might have been reasonable. But now, in retaliation, it would seem, plaintiff's counsel wants more money than the originally challenged amount. So in summary, innocent mistakes are made. No one's perfect. As the court knows, the basis for sanctions is CR 11, which empowers the court to assess terms when appropriate. There's nothing in the rule about penalty. It's about recovery of reasonable expenditures. Construed by case law, courts may invoke CR 11 to impose terms in consideration of setting aside a default. We know that. But the quote is, and I'm citing Griggs v. Everbeck Realty, 599 Pacific 2nd, 1289. This is a 1979 case among many, that the terms need to be in accordance with equitable principles. Here, there was an untimely answer to a complaint where a notice of appearance had already been filed. Any further delay could have been avoided. I had the plaintiff's counsel stipulated to vacating the default. In fact, I think it was a useless act to challenge the motion for setting the default aside. These are routinely granted. So the fact that to the extent that any sanctions are equitable, the court shouldn't award more than an hour of attorney time. And I might just add that, as the court knows, again, default judgments of any sort are not favored in the law. Well, I'll stop there. I may want to mention something else later, depending on your observations.
Yeah. Ms. Tideman, any response?
Yeah, I guess I probably have a different understanding of kind of the basis why we're here. So when Commissioner Nelson heard the request to overturn the default, we, at that time, the order was that he was going to grant that request, but that my client was entitled to all fees that order continued to be set. The concern on the motion for reconsideration, at least from my understanding, was only that there wasn't a fee affidavit to support the $1,000. And so because he referred to that seller's case, and this isn't CR 11, this isn't sanctions, this is literally just attorney's fees because the default was taken, and that seller's case does suggest and has awarded attorney's fees in that matter for obtaining the default and to defend against overturning the default. So that was the basis of Commissioner Nelson's decision to award fees. He's already made that decision. So we're not here. And honestly, when I requested the $1,000, part of it was I hadn't even requested my time to defend against overturning it because I truly was trying to be reasonable. I just didn't want my client to be out money because of the situation, right? He's had to pay fees that were incurred as a result of us obtaining a default. And that's why in my fee affidavit, I actually split them out so the court could see kind of the time for each. And so to just obtain the default, my client had $983.50 plus an $8 cost to just obtain that default. And then there were fees incurred to defend against it. But my total fees were $2,671. I only requested the $1,000. I'm actually not, I wasn't planning to request more. I think I have to rely on my previous request that was in my responsive answer, which was the $1,000. And that was made truly in an attempt to be reasonable and not try to make this more difficult than it needed to be. But my concern is obviously my client. My concern is that he did incur attorney's fees as a result of this. Those aren't fees that I've written off of my bill. So he has had to pay those and he should be compensated for them. And $1,000 is reasonable. And again, I guess my argument slightly is different than Mr. Penta's, and he seems to be making an argument that fees shouldn't be awarded or they should be very little, when my understanding was that Commissioner Nelson already indicated I should receive fees for obtaining the default and for defending against it. It was just that we needed a fee affidavit so that if those fees requested when Mr. Penta looked at the fee affidavit were somewhat unreasonable, that would be the discussion we were having, not whether these fees should be awarded at all.
Mr. Penta, any response?
I appreciate counsel's position. Obviously, I appreciate the judge's position. It comes down to reasonableness. I think the bottom line is that all of our wasted time and these billable costs to her client could have been avoided. There's just no reason that we had to take this step at this point and invest so much time in a routine matter that could have been handled by stipulation. So everything that was incurred, I won't call it padding expenses or churning, but everything that occurred that was billed out was unnecessary.
So I understand the party's position, and I do recall this case when default was originally entered. And one of the things the court took into account at that time was that the complaint and summons had been filed February 24th. And there wasn't actually a request for default until May 10th is when that hearing was. So this wasn't a situation where plaintiffs waited just 20 days or 21 days and requested a default. I think the court was also looking at the amount of time that had lapsed since the original complaint was filed. I've certainly also reviewed Commissioner Nelson's ruling, which did set aside the default, but also found inexcusable neglect in making that ruling. So I do support his decision, and I understand his decision to award attorney fees in some form. And I think that that is well-founded in the facts of this case. So then I have to look at what would be a reasonable attorney fee given this case. In looking at the declaration of Ms. Tideman, in obtaining the default, we're $20 short of $1,000. I certainly understand, Mr. Penta, your position that following that default, the parties could have agreed to set aside, and certainly that is, as you noted, the favored outcome of the court. But I do think that the duty of Ms. Tideman was to zealously advocate for her client and defend against that, especially given the ultimate finding that there was inexcusable neglect in order, well, that was his finding despite setting aside the default. So I think there was enough here where this was not a clear-cut case of this was for sure going to be a default that would absolutely be set aside. So I think that Ms. Tideman's position is reasonable in that her original $1,000 request is below what was actually spent on this case. I am going to grant the $1,000 attorney fee request given all the facts of this case, and I will find that it's reasonable based on my review of the record.
Understood. Thank you, Your Honor.
Anything else from the parties on this matter?
I think I had submitted a proposed order to the court, and I think I honestly, I don't have it sitting in front of me. I can't remember if I left the fees blank. And I don't know if you have a copy of that, but
I know it's been one of those days. Well, let me see if it's sitting behind something like I found another person's. I'm not sure if I have that. Do you have?
We can circulate another order.
Yeah, if you don't mind circulating, I can sign that off docket.
Thank you, Your Honor.
Okay. Mr. Penta, do you have another matter on this docket?
Thank you, Your Honor.
Okay. Have a good afternoon.
Thank you.
All right. Do I have Douglas Jensen online? All right, we'll call this matter. Good afternoon.
Good afternoon.
And I think I saw Mr. Mers present.
Correct.
Okay. This is 232-0050-508. Give me just a minute to get that digital file pulled up. Okay, I have my original notes noted that this was put on today's docket for plaintiff's motion for default. I do have that motion and declaration for default, but then I have some defendants. I have some subsequently filed July 7th pleadings regarding the request to strike pleadings. So I guess first I'll turn it over to you, Mr. Jensen, to kind of fill me in on why we're here and what you're requesting of the court.
Absolutely. So the matter was filed in May. Defendant was served the following day. No responsive pleadings were filed with the court. As I noted in the motion for default, the county is compliant with both statute and civil rules on the summons and the content of the summons. Instead of responding with a filing, the defendant sent a multi-page correspondence to this office and never did file an answer to any type of response to the complaint. Out of necessity, we filed a motion for default. And that triggers an action by the court to address an appearance by the defendant and whether he can file any motions as a consequence. The county also in equity sent him a notice as well of this proceeding, which is why that triggered a, for lack of a word, a response to the county's motion for default. The county then sent a short reply back to the court indicating the reasoning and the basis for his response, that it was simply lack of knowledge, lack of understanding, lack of an approach compliant with both the civil rules and statute in how you approach responding to a court filing. And in doing so, I cited CR 55, which has two tenets to it. Number one is that arguably he wasn't entitled to notice, but we did give him notice. But secondarily, before he could start filling the court file with documents, he needs permission by the court. And so I've asked appropriately that his filing be stricken. We're back to square one. If the court is predisposed to allow him to continue and not sign the order of default, I'd requested a pretty short window for a response, which is July 21st. Like I said, that would put this matter at almost 60 days since the time of filing of the information. And as I noted in the complaint, this matter involves really a issue of public interest and continuity of governance and for the city of Kalama.
Thank you. Mr. Mers, your position.
Well, my position is that I tried as hard as I could to comply. I would say, smarter than the average bear when it comes to reading the law. 7.56 seemed incredibly vague. Trying to find out what an information was, exceptionally difficult, and then how to respond to that. So I did just rely on what Mr. Jensen sent me, which said, in order to defend against this lawsuit, you must respond to the complaint by stating your defense in writing and by serving a copy upon the person signing the summons within 20 days. And so I tried to comply. And obviously that's why I filed the opposition as soon as I found out.
Okay. So, and you folks, and Mr. Mers particularly for you, and Mr. Jensen obviously is aware of this, the court does favor resolutions on the merits. There's appellate decisions making that very clear. I do find, so Mr. Mers, technically you have not filed an answer yet to the lawsuit, but we're going to talk about that in a minute. Okay. I do find that you have, with some diligence, tried to file that answer. I'm not going to order default because you have been active in this case. It can be distinguished from cases where people don't, for months and months appear in a case and then they show up and want to participate. I don't find that that's the case with you. You have filed something. I am going to strike the pleading, though. I'm not going to, the pleading that you did file is not an actual answer. Okay. So I'm going to deny the motion for default. I am going to set a deadline for you to file a formal answer to the summons and complaint. I can't give you legal advice on that, so I can't really go too much further with what that should look like. So if you do need to seek counsel to do that, please do so. I think there will be less leeway if we continue to kind of have a series of filings that are inappropriate and not actual answers. So we are looking for something that's an actual answer to the lawsuit. Because, and I was just looking, hold on one second. So this summons and complaint was originally filed with the court on May 23rd. And then when did you receive it, Mr. Mers? When was it served on you?
The 24th.
The 24th. Okay. So we're coming up on 60 days since that's been pending, which is, quite some time outside a typical answer period. How much time would you need to properly respond to the summons and complaint?
May I ask, do I need to include relevant evidence with the response, or is that what I include later when they request the hearing if they choose to?
Yeah, so I can't give you legal advice. I can tell you that typically what an answer would look like is you would look at their complaint and they've numbered each of their allegations, and you're needing to admit or deny their allegations. And then you do need to also make any affirmative defense requests that you want as part of this case.
Okay.
So beyond that, I can't go into what anything should specifically say. I would recommend you seek counsel if you want more information on that.
I would politely ask for 30 days because I'd like to get the judge's final judgment and actually be able to cite and quote what Judge Scudder did say.
Okay. Mr. Jensen, what's your proposal for timing?
The relevant attachments to the complaint, which, this is an action under quo warranto. And what's required for quo warranto is establishment of a conviction of a public official while in office with a felony. So we have the actual judgment, we have the charging, the public cause statement, the jury verdict, the judgment, and then Mr. Murr's refusal at a City of Kalama council meeting to voluntarily vacate his office. This is a matter in ouster. It's not a matter in punishment. Basically, the courts have taken a position that upon entry of the judgment itself, that the public office is vacant, the public office is forfeit, and the ouster is simply a judicial mechanism to enforce involuntary removal following a refusal to voluntarily vacate the office. So quite honestly, the City of Kalama still is ongoing with its city council meetings. Mr. Mertz is still attending, participating in the governance process, arguably in the face of what the law says has happened.
Mm-hmm.
I'm setting July 21st as a drop dead date. He chose to proceed post se.
Yeah.
Galatians 6 verse 7, you reap what you sow.
So Mr. Mers, here's going to be my ruling. I do think 30 days, given the facts of this case, is a lengthier period than I would typically authorize. So hold on one second. Oh my gosh, thank you. I know you got a lot of emails. Yeah. Thanks. Okay. I will give you 14 days. That'll put us to July 26th. It's a little bit longer than Mr. Jensen is proposing, but I think under these circumstances, strikes a balance between the public interest, certainly in assuring that, we're doing the things we're supposed to do as public officials. So I will set that 14-day deadline to July 26th. That is the date that by that date, you will have to have served plaintiffs in this matter your answer, and you will have to also by that date have filed it with the Superior Court clerk in this matter.
Okay, great.
Okay.
Thank you.
Anything else today that we need to do on this case?
I don't believe so, Your Honor.
Okay. Does Mr. Jensen, would you be willing to prepare an order that denies the default and sets the answer deadline?
Of course, and I'll provide Mr. Moose with a copy of the proposed as well.
Okay, great. Much appreciated.
Thank you, Mr. Jensen. Thank you,
You're
ma'am.
welcome.
Thank you.
Have a good week.
Thank you. Okay. Besides our summary judgment case, I know, Mr. Fry, you're probably itching to get to that, and I will just as soon as
I don't have any itches.
Okay. Do we have Gordon Veal or Tyler Jordan with us? Okay, I'm gonna call this matter, it's number 7 on our docket. 222-008-6608. And this was supposed to be, as I understood it, in order to show cause why the court should not dismiss the case. My understanding is this is an appeal from a lower court. The last time the parties were here or supposed to be here was June 21st in front of Commissioner Nelson. No parties were present and the court did prepare the order to show cause. The notice was sent by court administration on June 22nd to both Mr. Jordan and Mr. Veal. The order to show cause specifically stated, if you fail to appear via Zoom, the court may dismiss this case without further notice to you. At this time, on its own accord, given Judge Hahn's June 22nd amended order to show cause and having found proper service along with prior failures to appear, the court will enter an order dismissing without prejudice at this time this matter. And I can prepare that order. Okay. And then do we have Kevin Parker or Chevron Jacobson present? Okay, let me go ahead and call that matter 232-002-9908.
Hello, Judge.
Yes, who is this?
Rick Larson for Jacobson Chevron.
Oh, great. Okay. So we do have you here. I'm just looking to see what we were expecting to do today. It looks like this was a readiness hearing. You filed a brief of respondent.
Yeah, we're very unclear as to what Kevin Parker is seeking. He's already had his court hearing regarding a tow, an impound tow. And of course, we were presumed incorrect and were awarded the fees. He has not paid. We do not seek them, but he was given a court order to pay them. I think wanting to do away with the court order to pay the fees.
Yeah, so he did file this notice of appeal claiming errors were made, the vehicle was licensed. What happens after that is that a case schedule is set. I don't see that he's complied with the filing of the brief of appellant. You complied with filing the brief of respondent, and he has not filed any reply to that. A readiness hearing was set for today. That is a mandatory appearance. He has not complied with any of the deadlines to date in this case. He is not present. What I am inclined to do is we'll have the court prepare, similar to one of the last cases that I had. The court will prepare an order to show cause. We'll set it on for 2 weeks, and he'll be notified that failure to comply or appear at that time may result in dismissal of this action.
Okay.
So nothing more for you to do except reappear on this docket July 26th at 2 o'clock.
July,
Oh, yeah.
okay.
Yeah, July 26th at 2 o'clock. We'll send out that notice to both you and Mr. Parker. If he fails to appear at that time and or still has not complied with any of the briefing schedule, the court will entertain dismissal of the appeal.
Okay.
Okay. Any other questions for me?
No, you answered them all.
Okay, great. You're free to log off. Thanks for being patient with us on this lengthy docket.
You bet. Thank you.
Thank you. Then let me see who I have left. Is it just our summary judgment motion case? Or I see Joshua. Yeah, what case are you here on, sir?
Yes, hello, Your Honor. Good afternoon. For plaintiff Silverlight, the motion
Okay.
for summary judgment, I filed a notice of association of counsel. I'm subbing in for Jesse Conway.
Gotcha. Okay, thank you. And then Meredith Dishaw. What case are you here on?
Yes, same case, Your Honor.
Same
I'm
case.
for Hartford and Navigators on that summary judgment motion.
Thank you. Mr. Feliciano.
Yes, I am here for the same case, but I would like to let you know, Honor, we don't have a lawyer. We try to find a lawyer and we don't have success. And I don't know if possible, you can give me a little more time to find somebody who will help me to do the defense, because I don't know nothing about the laws.
And just help me understand which entity you're with.
Flawless remodeling service.
Oh, okay. Flawless Remodeling Services. Okay. Okay. I'll just ask the parties. We have a request from one of the parties for additional time. I'll hear a brief oral argument on that. We'll start on behalf of the plaintiff.
Thank you, Your Honor. I don't mean to kick it back to Mr. Fry. I mean, it is his motion. I do understand, as the court has indicated previously on this lengthy docket, that the court does like to hear matters on its merits. If Flawless LLC is indeed and works with actively trying to get a new attorney, I understand their previous attorney did withdraw. Plaintiffs don't necessarily have an objection to that. However, this is a summary judgment motion that has been cited on and then recited. So it is some resources for us to continue appearing on this docket.
Absolutely understood. Mr. Fry.
On behalf of the defendants, Miguel Cabral Jr. and Rick Hyde, Mr. Feliciano, we would love to check up with you and follow up with our claims against you. On November 23rd, 2022, this court entered an order for discovery sanctions against your company, Flawless Remodeling Services, LLC. The court struck all of your pleadings and they entered a default against you, and then they released the lien, the illegal and frivolous lien that you filed against my clients. And they also released the bond claim that you filed against my clients. You were going after my client's bond. And so we would like to know where you are so we can serve you with proper paperwork and subpoena you to a deposition. If you can disclose your address right now on the record, I would appreciate that. The court can look at Odyssey and see the multiple times over the course of many months that we tried to contact you and serve you with our claims, but you denied and escaped service. You have not been participating in this lawsuit at all. You have been dismissed, but I still think that you are personally liable, and my clients would like to pursue you to get a personal judgment against you and collect on that judgment against you. So if you don't mind, why don't you tell us your physical address and advise the course whether or not you will accept service by regular mail.
Yeah, my personal address is 1003 Northwest 139th Street, Unit 22, Vancouver, Washington, 98685.
Okay, because we've served that address many times, and you've not responded to any of these proceedings, and you've been held in default, and your previous attorneys have withdrawn from representing you, and all of your claims have been struck. So you have no place in this lawsuit anymore, and I don't welcome your input, but I would like to pursue you for a personal judgment against you on behalf of my clients for the damages that you've caused them.
You know, I didn't cause damage to him.
So, yeah, and I think we're getting a little outside the scope of where I want to go with this questioning. So, Mr. Feliciano, I am going to deny your request for any sort of continuance. I think Mr. Fry is right. I don't think you have standing to make that request at this time. There's a very lengthy history of this case. And at this time, I'm not going to take further, I guess, argument from you. So I'm going to turn it back to the parties on, are we proceeding today on the original request for summary judgment?
I think it depends. I mean, you know, if Mr. Feliciano intends to participate with the lawsuit, we would like his input. However, I think as the court's already indicated, he really has nothing to offer here. I
mean, do you anticipate that because he's appearing today, and it sounds like it's been difficult to find him, that there would be depositions taken of him that would impact anybody's motion or response today?
It may be moot at this point because, you know, he's already been held in contempt of court and the discovery sanctions have already been applied. So I don't know. I'm concerned why he even pops up here other than to cause consternation and trouble within my motion on behalf of my clients.
You know, I don't know nothing about the terms you are using.
Yep.
Like a stroke. I don't know what that means. But the thing is, last time I tried to connect to Zoom, and I can't. So now I was waiting here to see what's going on, and today I got the right room. So I don't know if you are right or not, but the thing is if we have some responsibility, we have to pay for that responsibility. But I didn't have the opportunity to talk because before one lawyer, then we got other lawyer, and they make a mess in the case. And I am not a
I'm
lawyer.
allowing a little, this is starting to feel more like a mediation conference than a hearing. I think we're kind of getting a little outside the realm of what things have been set up for. I could, if the attorneys would like to have a breakout room with Mr. Feliciano, I'm happy to coordinate that right now. Does anybody want that? I don't think we should have any more discussions on the record.
Yeah, I can't be a witness to the case to what Mr. Feliciano tells me. And my presumption is that he's appearing on behalf of Flawless Remodeling, that's a former defendant here, or maybe a current defendant for Silverlight.
Yeah.
But that requires counsel. You can't appear pro se if you're in an entity. You have to have somebody representing you. And so,
well, I mean, he could, if it's any sort of management, he's free to appear pro se.
I don't think LLC can represent themselves.
Well, I'm going to disagree with you on that, but I think that's neither here nor there on what we're doing today. So again, Ms. Dishaw, I haven't heard from you. How are you wanting to proceed today?
Your Honor, Flawless was Hartford and Navigator's bond principal. We have the ability to assert their defenses on our own behalf. I think based on the pleadings, Hartford surety specific defenses should dispute summary judgment as is. Obviously, we'll have more argument on that, but so I'll defer to the court and the parties as to what they want to do, but I'm not sure a breakout room is necessary at this time.
Okay. Yeah, I just don't want to take any more kind of factual evidence here in front of me. So if Mr. Fry, you're going to be asking more questions of Mr. Feliciano, then I don't want it done in this courtroom.
Okay, that's understandable. And I just redirect the court's attention to its prior order from November 23rd, 2022, which is discovery sanctions against Flawless Remodeling Services, LLC. And that would include Augustin Feliciano as a principal.
Well, just hold on. I understand that. And I see the prior orders the court has signed, but I'm going to bring us forward to what this was noted on for today. And what I am trying to get a sense of is, are the parties ready to proceed to oral argument on this specific motion or not?
We are, on behalf of the moving party, we are ready to proceed as insofar as you prohibit Mr. Feliciano from participating as I guess a pro se attorney for himself or for on behalf of Flawless Remodeling Incorporated or LLC, because we have had no, they've already been defaulted out of the action, and I don't want him jumping in at any given point in time.
Plaintiffs are ready to proceed in our defense of the motion for summary judgment.
Okay.
Happy to proceed in defense of the sureties on their motion.
Okay. Give me just a second here. Okay, so what I'll do at this point, given my review of the record, Mr. Feliciano, this is an open courtroom. You are allowed to be present. You are allowed to observe. I cannot preclude you from the hearing room. I'm not going to allow, you haven't filed any response specific to this motion, so I'm not going to allow any argument from you today, but you certainly are allowed to stay and observe.
Thank you.
Okay. All right, parties, go ahead. And I do go ahead.
Thank you, Your Honor. I'd like to ask Mr. Feliciano to mute his microphone. Thank you. And I mentioned the order for the discovery sanctions against Flawless Remodeling because it's kind of key to this motion. And then if the court, looks down the Odyssey line, you also see an order to dismiss LRI construction and the CBIC bond. Both of those are pretty telling on the entire case, and it really limits the factual issues that are at hand. That is, at this point, we're moving forward with summary judgment on the record, and I represent Miguel Cabral Jr. and Rick Ide as individuals, and they are asking, number one, to release, for the court to order a release of the Silverlight lien. So Silverlight filed its lien against the property. We're talking about a beautiful piece of property up on Ammons Lane in Western Longview in the foothills there. My clients built this property, and they started off with a really bad situation with some contractors that ripped them off. They paid $27,000+ to Flawless, and the work that was done was complete. It was obvious. It was unacceptable. If you look at the declarations, the concrete would just run right out of the forms that were built. And so they had an agreement only with Flawless. Currently, the place is built up and their mother-in-law is living there. It's a residential place. There's no question that title's vested in both Cabral and Ide. And here comes this ghost contractor. And I say ghost contractor because Silverlight never dealt with my clients directly. And they have never notified my clients that they were involved in the situation. They dealt exclusively with Flawless and had no interaction, no communication, no invoices, no literature, no letters, no notifications at all to the homeowners, which was Cabral and I that were building this home. And so we have set forth our argument in the summary judgment motion that I'm going to review in a little bit here, but we're asking, number one, the court should get rid of this lien from Silverlight because it had no connection to my clients, no connection to the owners of the property, never had any contract or anything like that, and award us attorney's fees because there's no basis for Silverlight to even have a lien against my clients, because Silverlight is a ghost contractor. They just showed up out of nowhere and did a little bit of work and filed a lien and left. Second, we're asking for a judgment against the bond company. Now, there's a little bit of a situation here. This is Flawless's bond company. So my clients had a contract with Flawless to do the initial dirt work. That is, you have a piece of land, you're trying to get the dirt moved out of the way, and then you try to build the forms for the initial foundation pouring. And what we have here is a situation where my client said Flawless has to do everything. We don't want anybody else involved in this. And the declaration should prove that. So they hired Flawless as homeowners. They intended to reside there. Their mother-in-law resides there currently, and at this number 3 Ammons Lane. And so we're asking that we get the benefit of the bond statute and have a recovery against Navigators. I'm sorry, Navigators. Right now, we went against both companies because Flawless had 2 different bond companies. But really, if you read through, and I'm sure that the council will mention this, but we're only asking for a judgment against the Navigators bond, and we don't have any intention to pursue the Hartford bond if it was outside of the area, and we just needed them to commit that to writing. And they've done so. And so we're not interested in the Hartford insurance bond, contractors bond. We're interested in the Navigators contractors bond, which was backing up Flawless. And the reason that we can get that is that it's a breach of contract. Flawless promised my clients, they promised us they would do the work. Nobody else would do the work. They do it in a specific piece of time. And it was basically just getting it set up to pour the initial foundation. And my clients found out, as the declarations show, that the Flawless did not do the work. And the work had like big gaps in it so that the concrete could just run out the sides. And so the forms weren't built appropriately, not according to the blueprints or anything. It's a clear breach of contract. I don't think it's that complicated. And when a contractor breaches a contract, their bond is liable to the homeowners, and that's what we're asking for here. So number 1, get rid of Silverlight's lien. Number 2, give us the Navigators bond. Looking through this thing could get really complicated, and it doesn't need to be that complicated because it's pretty simple. I've set out in my motion itself these undisputed facts, and none of them have really been controverted by any of the parties. So summary judgment is totally appropriate. There's no dispute, genuine issue of material facts or otherwise, that Cabral negotiated with Flawless. Flawless promised to perform. There was a $27,000 plus payment, $1,000 plus payment to Flawless, and what they got is a bunch of garbage. Not able to pour, not according to blueprints, not even close to the community standard. And time was of the essence, because you need to get the concrete poured in order to get the next guy on the job to start building the framing and everything else. And so there's significant damages that doesn't come in here. What we're worried about is where does Silverlight fit into this? What's their rights against my clients? And read through their motion and their declaration. They don't even know who they dealt with. They think they're dealing with RLI, construction contractors. They think they're dealing with whoever. They only had a contract with Flawless. Silverlight had no other privity of contract with anybody else. And they did not care. They didn't care at all whose property it was. They did not even interact with the property owners. They only dealt through Flawless. My clients had no idea who Silverlight was. Silverlight's a ghost. They show up on your property, they do some work, and you have no idea who they are. They're trespassers. They don't have right to enter or remain on the property from my clients. My clients only gave Flawless the right to do that. And Flawless had no right at all to hire subcontractors or independent people or employees, because that opens up a huge can of liability for my clients. And so the deal was, here's $27,000, get this done. It's not done. And it's a real clear-cut path. They're terminated. So there's no ability to fix this. They're terminated. Some stranger shows up on your property and now they have a lien against your property and going to foreclose on it without any disclosure statement. This is not what the lien statute's providing. That is, you have undisputed facts that Silverlight did not know or care about who owned the property. They only exclusively dealt with Flawless, and they were not ever dealing with the owners, Cabral or Ide. They did not know or notify or otherwise anyway indicate to Cabral and Ide, the owner of the property, that they were working on their property. They're basically trespassing. The disclosure statement that's required under RCW 1827-114, that's just fundamental. It's basic sense. I'm going to go work on your property. You have a right to know who I am. Okay, I'm going to disclose my credentials to you. The notice of a right to claim a lien, again, it's fundamental. You don't know who I am. I'm working on your property. I'm going to give you a notice. I have a right to claim a lien against your property. Who are you? Well, now you know. Nope, never given. And it's uncontested. The disclosure statement wasn't given. The notice of right to lien wasn't given. And there's no proof of any service of the lien itself. I mean, maybe it was sent by regular mail, but that's not what the statute requires. So we have a situation with Silverlight where it has no privity of contract, no connections, no agency, no authority, implied or explicit, with my clients, but all of a sudden they're claiming this legal authority to claim a lien against my client's property, and they're foreclosing on the lien after my client's already paid this guy $27,000 and fired him. Now we've got this ghost contractor my clients never even met or heard of, filing a lien against their property. we never authorized any of this. Well, sorry, we get our lien. And they're using the lien statute as, kind of a coercion tactic because they know property is going to ultimately be built up and these people are going to have a financial interest in paying off the lien so they can move on. And instead, we've got mom living there and it's still subject to the lien. There's no genuine issues of material fact that Silverlight only dealt with Flawless. The bond Navigators is obviously liable. Flawless is not here to testify or to provide any information. Agustin Feliciano may be, staring at us on the screen, but he's out of it. And we know that because the orders are in here to, the November 23rd order to dismiss them. And then also the order to dismiss RLI construction and the bond. The bond company may claim this isn't residential property, but it's obviously residential property. The mother-in-law is living there and it's meant for residential purposes. And if the bond is not applicable, why would Flawless itself file a claim against my client's CBIC bond? That is, Rick Ide happens to own a company. He ran some stuff through it, RLI, and they filed a claim against the bond. So the bond claim is, both of these should be very simple for the court to decide. So Silverlight had no connection with my clients. They have no right to lien. They didn't even follow any of the law in terms of the notification or any of the contact. And then the bond company, it's obvious Flawless defaulted and breached the contract and ran away. And just look at the court record. Look how many times we tried to serve him. He shows up on summary judgment. It's insult to injury, to be honest with you, Your Honor. And so we're asking the court again to enter an order releasing and disqualifying Silverlight's lien against the subject property, this residential property, and award attorney's fees under the statute that I've cited. And then on top of that, follow the law and give us the right to recover against Flawless's bond. It's not a lot. It's $12,000. Has nothing, nowhere close to the $27,000 plus all of the other damages we've lost. And let us recover just that minimal sum, and then we will move on and proceed with our collection action. Thank you.
Thank you.
Yes, thank you. Thank you, Your Honor.
And if you don't mind, I'm just going to stand. I've been sitting since 1 o'clock.
No, I understand.
I'm going to
Absolutely.
stand and listen, and I don't mean any disrespect by it.
No, not a problem,
Okay.
Your Honor. I understand. I guess just as a preliminary question, Your Honor, you are the court's in possession of plaintiff's response.
Yes,
Yes,
I
thank you.
have, and I should have said that at the very beginning. I have received and reviewed the original motion, all attached declarations. I have received the responses on behalf of both your client and Ms. Dishaw and her client, that included declarations. So yes, the court has received and reviewed all of that.
Thank you, Your Honor. I'll be brief then, not to rehash the response. I just want to start from a sort of a 500-foot view. Defendant's counsel is correct. Mr. Cabral, Mr. Ide, they are the property owners. But just to note for the court, Ricky Ide owns RLI Construction. And so that is essentially the point we're dealing with, where RLI then contracted with Flawless, who then contracted with our clients, plaintiffs, Silverlight. So that's sort of the three-tier structure. It goes RLI Construction to Flawless to Silverlight, 1, 2, 3. So just starting from that point, is plaintiff's position why summary judgment should be precluded? There are numerous issues of material fact. I'll just list four. The court has in plaintiff's response the other ones, but just for the main ones, there's inconsistencies in defendant's answers under oath, as well as in responses to interrogatories under oath, essentially, that who is the general contractor in this matter? On one hand, Mr. Cabral and Mr. Ide say they're the general contractor. On the other hand, they also say RLI was the general contractor. We believe the exhibits A through K attached to Mr. Manuel Martinez, who's the owner of Silverlight, will show that RLI Construction was in fact acting as the general contractor, even though Mr. Cabral and I'd want to say that they were the general contractors. Either way, that's a material an issue, a general issue of material fact. So that's one. Number two, defendants claim that there was some kind of a provision in the contract with Flawless, so RLI with Flawless, or Mr. Cabral and Mr. Ide with Flawless, that there was a term that no subcontractors could be hired. There's no evidence of that. Exhibit A to Mr. Martinez's declaration is the contract we're talking about. Outside, there's four corners of this document. There's nothing in here that says no subcontractors could be hired. You know, for parole evidence considerations, any oral agreement for some other term that can't be included here. So that's a issue of material fact. Number three, defendants claim that the work was defective. They point to a declaration saying that concrete was perhaps spilling out. There's no inspection report. There's no pictures. There's no other evidence. This is a self-serving affidavit declaration to that effect. Plaintiff Exhibit E provides a long view inspection report that indicates that the work was fine. It passed inspection with this quote, ready to pour. So there were no indications that the work was done improperly, and defendants never supplemented in the reply pictures or inspection reports or any other evidence to show that the work was defective. And finally, number four, defendants say they never received Silverlight's claim of lien. And that's paragraph 4.54 of defendant's motion. And then in this, we have, I believe it's page, well, it's actually exhibit C to Mr. Conway's declaration. In deposition, Mr. Ide and Mr. Cabral both admit under oath that they received the claim of lien. So that's, again, another issue of material fact. On the law with the notice requirements, we're looking at RCW 1827-114, where such disclosures for model disclosure statements for contractors contracting with other contractors, which is our client Silverlight contracting with Flawless, Silverlight was not required to jump past Flawless to inform the property owners or the general contractor that they had the opportunity or the ability to record a lien on a property. The case law is clear on this. They give these contractors who work directly with other contractors, who are most of the time laborers, which is what Silverlight was in this situation, basically an exemption or an exception to these model disclosure rules. So you're not required to, and some laborers, sometimes this happens in construction projects where a primary contractor is told to get the job done, and they might hire someone for concrete work, for framing or something, and they don't essentially require that laborer to have to provide a model disclosure statement to the owners or the primary contractor. You'll see again in that exception is also RCW 60-04031. Again, a subcontractor for the improvement of real property, directly working with a prime contractor, which would be Flawless here, is exempt from providing these notices to lien to the property owner. And finally, Your Honor, just sort of summarizing here, again, summary judgment motions are for when there are no genuine issues of material fact. We find just on their own here with the four that I listed, those are genuine issues of material fact. Summary judgment's not proper at this junction, and we respectfully ask the defendant's motion for summary judgment be denied, as well as their request for attorney fees.
Thank you. And Ms. DeShaw.
Yes, thank you, Your Honor. Well, first of all, I think we're now in agreement that the Hartford bond is not an issue and should not be held liable or have judgment entered against it on this based on the plaintiff's argument earlier today, and as set forth in our opposition. As to the navigator's bond, as counsel for the plaintiff just argued, for a lot of the same reasons, including some of the ones he just went over in the facts here, there are genuine issues of material fact that preclude summary judgment as to the navigator's bond. Initially, the biggest one is navigators bonded flawless as its principal for any breach of contract. And ultimately, what we have here is a question as to who that contract was with. And not only is that a question of material fact, depending on who that contract was with and depending on what role that person was in when they had that contract, can they make a claim against the bond? As plaintiff's counsel just argued, the contract appears to be RLI Construction, Mr. Ide's company, Flawless, and then Silver Lake. If RLI Construction, as the general contractor, had the contract with Flawless, under Washington law, they cannot bring a claim against Navigator's bond because they are an upper tier contractor trying to make a claim against the lower tier contractor. And Washington law says that's not allowed for the same reasons. Even if Mr. Cabral and Mr. Ide were the people that executed that contract, if they are doing so in the capacity as general contractors, they, for the same reason, cannot make that claim against the bond. It's to protect the other public. Washington law doesn't allow an upper tier to make a claim against the lower tier's bond. Defendant's counsel argued earlier, and I think he was sort of conflating two different issues, but his argument was essentially, well, if Flawless made a claim, obviously that our claim should be valid. And I think there are two different issues here. First of all, if Flawless made a claim against RLI's bond, which it did, that further evidences the fact that the contract was with RLI Construction and not Cabral or Ide. Second of all, Flawless's claim, regardless of whether it was valid or appropriate and is now dismissed, has nothing to do with Cabral's and Ide's complaint against Navigator's bond. And there are other issues of material fact here too. Defendant's counsel is now claiming that they're homeowners and should be entitled to the $12,000 under the bond. But the allegations in the complaint were that this was going to be an investment, that they were acting as general contractors. And the statute requires that either the owner or the lessee intend to live in that house. Right now, we don't have any evidence that the owner is. If Mr. Cabral and Mr. Ide are not living in the house, then they are not an owner living in the house. And while we hear today in the argument that someone's mother-in-law is, it's not clear she's a lessee. It's not clear that this is an investment property. There are just too many issues of material fact as to A, Navigator's liability, and B, what, even if that liability could be established, which we don't think it can be for all the reasons in our opposition, as well as what we've argued here today, what that liability should be limited to. And for that reason, Your Honor, we would request that summary judgment as to Navigators be denied, as well as Hartford, as we already talked about.
And then Mr. Fry, do you want some response time?
Yes, Your Honor. Thank you. I would like to thank Mr. Volvodnik and Mr. Shaw for their input today. Unfortunately, I guess we're stuck with the declarations and the facts and not speculation or innuendo. And it's pretty clear that these Silverlight has no idea and doesn't even care until now who owned the property or who had the contract or whatever. All they cared about was they had to deal with Flawless and Flawless only, exclusively Flawless, to do some work and get paid by Flawless, not by Rick Ide, not by Miguel Cabral, not by the owners. And asking about, well, there's this contract. I mean, there's the only piece of evidence that's in the declarations is there's an estimate that's signed by Miguel Cabral, not signed. There's nothing with RLI on it. So I think that RLI got pulled into this initially because Rick Ide and his wife have a contracting business, but that's not who owns the property. Let's look at the deed. Let's look at the liens. The liens don't claim against anybody else but Flawless. And so, that's Flawless's lien and Silverlight's lien, they list the property owners. And there's no dispute. There's no question of material fact that Rick Ide and Miguel Cabral own the property. And so, this is chasing around innuendo and speculation, but it has nothing to do with summary judgment. Summary judgment is going to be based on the evidence presented so far, and it's not going to be guessing about what could have, should have, would have been. There's the whole point of the idea of a lien is to protect the contractor who contracted with the homeowner or dealt business with the prime contractor. But there's no evidence that Flawless was a prime contractor. In fact, that's ridiculous. The evidence is that Flawless was only hired to do the dirt work only. That doesn't qualify them as a prime contractor. There's no question at all, no genuine issue of material fact that Rick Ide and Miguel Cabral Jr. hired Flawless and Flawless only exclusively to do the work. And this ghost company shows up, does a little bit of work, and it's completely inadequate, and then moves off the property and then files a lien without any notices, without any proof of service, without anything. And in terms of if this case can't recover on a bond between two individual owners with their mother-in-law living there, I don't know what case would cover on a bond. It's to protect the homeowners in a residential situation, and that's exactly what we have here. And so the attorneys make this sound very complicated. They've filed a lot of complicated motions, speculating, using innuendo, and guessing about what could have, should have been. But the bottom line is Rick Ide and Miguel Cabral Jr. have complete ownership of this. They contracted with Flawless. Silverlight should not have a lien, and Flawless breached the contract. Obviously, that's uncontested, and they should be able to recover at minimum the full amount of the bond. And that's all we're asking for today. So, Your Honor, I think that this could be simplified very easily if you review the records and the files online, and especially considering that Flawless has not participated and has not contributed any evidence to the case so far. I think this is a very easy decision for the court, and I'd ask you to grant the motion as presented. Thank you.
Thank you. So here's my plan. I appreciate the parties' oral argument today. I know sometimes oral argument on pleadings is redundant and, leaves you thinking, oh, I could have just read it. But I do actually truly appreciate the clarity that all three of you brought to the case, especially with me being a commissioner coming on so late in the game to this case. So I do appreciate it. I'm going to take it under advisement and issue a written decision by Wednesday of next week. So just 1 week. I understand your trial is a few months out, so I don't think that 1 week will prejudice any sort of trial preparation. So by Wednesday, the court will email all of the parties in the case my written decision on this motion.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you, Your Honor.
And then with knowing that that's coming, are there any future dates you need to set on this civil docket? Or do you want to wait and get that ruling and then you can note on any additional issues if you want to?
The issue will be presenting an order. I know that the bond company has presented a proposed order, but it's not going to be consistent with whatever the ruling is. And so we will need to have a date established to present either an agreed order, or we can argue about the order after we read your, I've got to after I read your decision, I've got to prepare an order, and then if the other parties just agree, great. Otherwise, we can argue about that at a future hearing on a civil docket.
Yeah, to save everyone a little time. I mean, I know you folks are all spending a lot of time on this case. I'll get you my written decision by the 19th. We could set a presentation date just as a placeholder so that you guys don't have to go through the process of noting it. Do you want to do that or not?
I'm going to have to see the decision, and unfortunately, I can't open my calendar up to free assignments. I don't know. I welcome council's input on that, though.
That's okay. I'm just trying to save a step and not have to have you folks noted on to another docket. But why don't we just at this point, I'll get you my written decision, and then I'll put it back in your court to, I guess, talk amongst yourselves about a presentation. It would be back on this Wednesday docket at 2:00, whatever it is. Okay.
Thank you, Your Honor.
Yes, thank you all for your time. I appreciate it.
Thank you, Your Honor.
Okay, and I don't think I missed any cases. Do you have anything missing? Just a bunch